We will hear arguments in the case Free Speech Coalition versus Paxton. Counselors, whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Shayla Bergen, and with my partner, Emmy Maeda, we will be representing the petitioners in today's case. Justice Kennedy stated in Ashcroft v. ACLU that content-based prohibitions have the constant potential to be a repressive force in the lives and thoughts of free people. The respondents threatened to do just that by restricting adults' access to constitutionally protected speech under the guise of protecting children. This court should reverse the Fifth Circuit decision for three main reasons. First, HB 1181 is a content-based restriction subject to strict scrutiny. This court affirmed this in precedents Reno v. ACLU, Ashcroft v. ACLU, United States v. Playboy, and others that meet content-based restrictions require strict scrutiny, a standard HB 1181 does not meet. The law is not narrowly tailored and fails to consider less restrictive alternatives.
In doing so, the Fifth Circuit decision departs from precedents and overextends Ginsburg v. New York's purview. Also, the law is both under-inclusive and over-inclusive. Social media platforms and search engines host harmful sexual content, but would not be regulated since it does not fulfill the one-third threshold. But it's also over-inclusive in that just one-third of sexual content on a website can warrant restricting two-thirds of constitutionally protected speech. And finally, the law unconstitutionally compels speech. States must prove that disclosure requirements are neither unjustified nor unduly burdensome. Texas proves neither. We ask this court to reverse the Fifth Circuit court decision and apply strict scrutiny.
Thank you. What, if any, is the value of low-level speech, such as pornography?
Your Honor, it's true that pornography and sexual expression evoke varied reactions from acceptance to moral condemnation. However, in US v. Playboy, the court stated that, quote, aesthetic and moral judgments about art and literature are for the individual to make, not the government. This principle protects personal autonomy in consuming and evaluating such works, and it prevents governments from suppressing disfavored speech. The pornography genre is subjective and can range from more hardcore content to classic erotic poetry or Renaissance paintings or modern cinema. And these works contribute significantly to cultural and social and political discourse. And laws like HB 1181, which broadly restrict depictions of sexual anatomy, could even ban celebrated works and educational works as well. And these subjective judgments are not for the government to impose onto citizens. And even if pornography is simply entertainment with no other value, its importance should not be undermined. In fact, in Brown v. Merchants, they said that this court has long recognized that it is difficult to distinguish politics from entertainment and dangerous to even try. Finally, while unsavory, offensive, or quote-unquote low-level to some, these forms of expression have been a driving force of human history, and the government's interest in shielding minors does not grant it authority to broadly suppress constitutionally protected speech or to undermine its value.
Thank you. Was the First Amendment created to protect this kind of speech, and does that matter here?
The First Amendment begins with a clear mandate. Congress shall make no law abridging the freedom of speech. Its very purpose is to protect the speech of citizens from government overreach, which is precisely the issue at hand. It is also intended to protect controversial and unpopular speech, like indecency, that the government may find offensive. While the framers of the First Amendment likely did not have pornography in mind, the Constitution has evolved to address developments like the internet and social media. Whether or not pornography was part of the original intent does not matter. What matters is that the constitutionally protected speech is being restricted here. And the court has adapted their decisions to the changing technologies. For example, in Joseph Bernstein, Inc. versus Wilson, the court writes that despite new motion picture technology, the basic principles of freedom of speech in the press, like the First Amendment's command, do not vary. There is no justification in this case for making an exception to that rule. The Supreme Court must intervene to uphold these protections and remedy the lower court's decision, as it has consistently done in both Ashcroft vs. ACLU's, US versus Playboy, Ashcroft versus Free Speech Coalition, Brown versus Entertainment Merchants Association, and Sable Communications versus FCC. These precedents make it clear that the First Amendment applies here, and we are simply asking the court to enforce the same standards in this case.
Thank you. Whose First Amendment rights are impacted by the Texas law? Is it minors, adults, or the platforms themselves?
Yes, Your Honor, it's all three of these groups that are impacted by the Texas law. First, adults are impacted. HB 1181 places significant burdens on adults' access to constitutionally protected speech. And Ashcroft Free Speech Coalition states, speech within the rights of adults may not be silenced completely in an attempt to shield children from it, but HB 1181 does so. The law's age verification provisions requiring digital identification, government-issued ID, or other commercially reasonable methods first disproportionately affect adults without federal or government identification and effectively bars them from ever accessing or engaging in this speech. And moreover, these measures pose significant security risks such as extortion, ransomware, identity theft, credit card theft, as pornography websites are frequent targets of cyber attacks. Requiring adults to submit sensitive information removes the anonymity otherwise available on the internet, and it also stigmatizes the speech and deters users. Even when the case has no criminal impacts, these burdens still create a chilling effect. And though our friends on the other side might argue that obscene speech isn't protected for even adults, HB 11 restricts beyond obscene content for all content that may be harmful to minors. And second, it also harms the platforms. Reno v. ACLU noted the economic impact of age verification requirements, saying that advertisers rely on the visibility and accessibility of these websites. But by imposing such restrictions, HB 1181 risks damaging website traffic, revenue, and advertisements. And also, the disclosure requirements also compel speech that drowns out their message and burdens their revenue. And finally, the Texas law burdens a level of speech for minors not accepted by this court. Minors are entitled to some First Amendment rights as established in Tinker v. Des Moines, and this arbitrary standard of 1/3 means the law could restrict 2/3 of non-obscene, non-sexual speech protected for even minors. Thank you.
Thank you. Why can or can't the government simply ban pornography online?
Yes, Your Honor. The critical distinction that must be made in this case is that pornography is not synonymous with obscenity. Indecent but non-obscene content is protected in the United States under the First Amendment, while obscenity is not. Because of this, the government cannot broadly restrict pornography unless it passes the strict scrutiny standard. Obscenity is classified by the Miller test, meaning that it depends on whether the average person applying contemporary community standards would find the work taken as a whole appealing to prurient interest, whether the work depicts or describes in a patently offensive way sexual content specifically defined by the applicable state law, and whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. There is much pornography available that is indecent as opposed to obscene for the standards above. Therefore, it is nearly impossible for the government to entirely ban the diverse genre of entertainment that is pornography. Some pornography can have artistic, political, or scientific value, and it would be government overreach to ban the entire genre. To name a few examples from the dissent, the show Game of Thrones, The Color Purple, and Marlon Brando movies might be considered harmful to children, but adults can benefit from their artistic value. It would raise vagueness and overbreadth questions. And even if the government did try and define pornography, remember that Miller warns that, quote, this is an area in which there are few eternal verities. And realistically, even if the government banned access to pornography, pornography is so entrenched in people's lives that people might just find ways to circumvent the restrictions, and it might mean that they pursue more dangerous foreign websites with little oversight.
Thank you. In what ways is the Texas law a content-based imposition on speech, and in what ways is it not?
Your Honor, the Texas law is a perfect example of a content-based imposition on speech. This court held in Reed v. Town of Gilbert that any speech that, quote, singles out specific subject matter, in this case, sexual content harmful to minors, even if it doesn't target viewpoints within that subject matter, is content-based and subject to strict scrutiny. Our friends on the other side argue that it can't be content-based since it doesn't restrict the content itself, but the platforms. However, Reed rejects that definition of content-based. And since HB 1181 targets speech based on its communicative content, it is by definition a content-based restriction. And the state tries to avoid this content-based discussion by avoiding valid case law like Ashcroft, Brown, and Ashcroft Free Speech Coalition by focusing on Ginsburg instead, saying that Ginsburg applied rational basis review, we should do the same here. But that's simply not true. It fails to account for the later precedents, and this interpretation of Ginsburg overstates its scope. Ginsburg addressed the First Amendment rights of minors concerning the sale of indecent materials in physical stores. It did not restrict adults' constitutionally protected speech. If HB 1181 targeted only minors' rights, it might require only rational basis, but the law imposes significant content-based restrictions on adult speech, triggering higher scrutiny.
Thank you. Is including social media and search engines under the age verification requirement a reason to find this law unconstitutional?
Yes, Your Honor. HB 1181 fails to address the substantial role both social media and search engines play in providing minors access to sexual content, making it both over-inclusive and under-inclusive. Social media platforms and search engines are among the most accessible source of explicit material for minors. However, because the majority of the content on these websites is non-sexual, these platforms do not meet the arbitrary 1/3 threshold established by the law. For example, one of the largest and most accessible platforms, X, formerly known as Twitter, reported that approximately 13% of all content on Twitter was adult content, according to internal documents. This creates an under-inclusive gap in its effectiveness, as the harmful sexual content available on social media is no less impactful than content on explicit websites like Pornhub. The law's over-inclusive nature is equally as troubling. By targeting websites where 1/3 of the content is sexual, it imposes broad restrictions on the remaining 2/3, which may include content of significant artistic, educational, or political value. This court has consistently rejected such sweeping restrictions on not obscene, constitutionally protected speech in cases like Ashcroft versus ACLU and Reno versus ACLU, especially when the law doesn't consider its less restrictive alternatives. Additionally, the law's failure to regulate social media and search engines creates a paradox. By focusing on smaller websites dedicated to explicit materials, it ignores ubiquitous, massive platforms that minors are exposed to daily.
Thank you. The law requires age verification when more than 1/3 of the website's content is inappropriate for children. Would the law be more or less burdensome if the threshold was increased?
Your Honor, hypothetically, if the threshold was increased, the law would be less burdensome, but still no more narrowly tailored or effective. If we think about it, increasing the fraction of sexually harmful content required for a website to be restricted would decrease the fraction of protected speech also regulated by the law. So theoretically, websites with, say, 40% sexual content might not require age verification. A site with 40% sexual content could still feature material that is educational, artistic, or political in nature, but under the law, it could still face age verification requirements that limit access to lawful speech, meaning that the law is still over-inclusive and most definitely under-inclusive. If the government allowed minors to access the 40% of sexual content on that website, which could amount to millions of images and millions of bytes of information, they would not be accomplishing the interest they purport to be serving. But also, we argue that a threshold is inherently flawed. First, HB 1181 doesn't define how sexual content is measured. Is it in the number of pages, posts, like bytes of information or images? We don't know. And also, no matter the threshold, whether it's 1/5 or 2/3, there is going to be harmful content that escapes the threshold and constitutionally protected speech that gets restricted. So it's inherently flawed.
Thank you. Ashcroft versus ACLU applied strict scrutiny to a law that burdened adults' access to online speech, not the rational basis test. Why should the court not apply the same standard here?
Your Honor, you're right. The court did apply the same standard. Ashcroft versus ACLU required strict scrutiny, and the court held that the Child Online Protection Act was not narrowly tailored enough and that less restrictive alternatives, such as the use of filtering software, could be used to achieve the same government interests. Ashcroft is not alone. Erzosinick versus the City of Jacksonville underscored that content-based restrictions on sexual speech cannot be justified under the less demanding rational basis standard, making it clear that such regulations require strict scrutiny. Similarly, in Denver area versus FCC, the court held that imposing content-based regulations on publicly available television networks is unconstitutional unless strict scrutiny is applied. Further, in Reno versus ACLU, the court struck down the 1996 Communications Decency Act, which allowed content-based regulation of indecent and obscene material while also burdening adult speech. Justice Kennedy remarked that the reasons the government offers in support of limiting the freedom of speech have no justification in our precedents or in the law of the First Amendment. Given these precedents, HB 1181 must be subject to strict scrutiny as it imposes content-based regulations on sexual material and burdens adult speech. Additionally, as these cases indicate, any such regulation must be narrowly tailored and must use the least restrictive means available to accomplish the government's interest.
Thank you. Ashcroft versus ACLU identified that content moderation through filtering settings was a less restrictive means of protecting minors online. Has that proven true in the time since Ashcroft?
Your Honor, content moderation through filtering systems has been thoroughly established as a less restrictive way of protecting minors since Ashcroft, and that holds true. Filtering systems allow parents to customize filter settings depending on the ages of their children and what type of content they find objectionable. And filters continue to place the responsibility of children in the hands of their parents. In United States v. American Library Association, this court accepted that filtering systems were a valid and effective restriction. And Ashcroft v. ACLU similarly cited filters as less restrictive than criminalizing speech, noting that, quote, promoting the use of filters does not condemn as criminal any category of speech. So the potential chilling effect is eliminated, or at least much less diminished. And although filtering systems aren't perfect, they still provide a better alternative to protecting minors than age verification. And Justice Kennedy authored in the same case that the government failed to introduce specific evidence proving that existing technologies are less effective than restrictions in COPA. And the same similar situation presents itself here, as the respondents have not introduced specific evidence that filters and device-based filtering systems are ineffective compared to age verification technologies. And if anything, these filtering systems have improved since then because they can now be installed directly on devices, meaning minors can't use VPNs to avoid these HB 1181 regulations, and they can't use parent ID to bypass an age verification wall. And also, recent AI can filter through content faster and more accurately than ever before.
Thank you. If the court were to find that the Texas law burdens the First Amendment rights of adults, does that mean that petitioners win?
Yes, Your Honor, it does mean that the petitioners would win. Now, it's true that in rare cases, a statute can burden the First Amendment rights of adults and still survive, but they must pass strict scrutiny. This Texas law would not, and petitioners would win their case. As this court affirmed in Sable Communications versus FCC, the mere existence of compelling interest does not excuse overbroad regulations. This is because a recognition of burden would trigger strict scrutiny, which would require a much higher standard of the HB 1181 law and require the government to narrowly tailor their statute. Texas does not. Petitioners have identified less restrictive options, such as device-based content filters, that effectively block harmful content without intruding on adults' constitutional rights. Furthermore, HB 1181's over-inclusiveness restricts access to websites with substantial non-sexual content. And it also has under-inclusiveness, as it has a failure to address alternative platforms like social media. And it shows that this law is not narrowly tailored. Age verification is not the least restrictive nor effective means of deterring minors from adult content.
Thank you. Adults concerned for their privacy may not access websites requiring age verification. Is that sufficient reason for striking this law down?
Yes, Your Honor, it is. It is a sufficient reason because, as stated previously, by requiring age verification, it creates massive privacy concerns like extortion, tracking, identity theft, or credit card fraud, and malware attacks. And this deters adults and even punishes them for accessing pornography, which is constitutionally protected. And furthermore, sexual preferences are exceedingly private to an individual. But these requirements stigmatize this speech and the targeted sites and impose fear of reprisal onto the users. And it's true, there are cases where thousands of users of information and IP addresses have been exposed to the public because of these pornography websites. Now imagine how much worse it would be when age verification requirements require adults to submit their information. And by asking adults to submit sensitive information in such an insecure way, the government is in effect asking them to forfeit their sense of safety and privacy to access constitutionally protected content.
Thank you. If the court finds that the law requires examination under strict scrutiny, does that mean that petitioners win?
Yes, it would mean that petitioners would win. If HB 1181 requires strict scrutiny, it fails as it imposes significant burdens on adults' access to constitutionally protected speech while not being narrowly tailored. HB 1181 would restrict beyond obscene content for all content that may be harmful to minors. And the 1/3 threshold allows the government to burden 2/3 of a website's constitutionally protected speech. It also doesn't consider less restrictive and simultaneously more effective alternatives. Filtering technology has improved significantly, offering solutions directly on devices like phones or computers. Device-based content filtering software cannot be bypassed using VPNs that allow users to mask their location and bypass geographic or platform-based restrictions. If more children start using free VPNs that are easily accessible, it exposes them to more security risks, including exposure to malware, DDoS attacks, and data breaches. Moreover, VPN usage can prevent parents, school administrators, and internet providers from monitoring a child's online activity and encourage minors to resort to underregulated, foreign, and dangerous websites. The difficulty of enforcing these websites, combined with the stigma caused by HB 1181, means that more children will be exploited, more children will be exploited and will be less likely to report their situation to a trusted adult.
Thank you. Are the privacy concerns presented by online age verification similar to the privacy concerns required to access age-restricted purchases in a traditional brick-and-mortar store?
No, Your Honor. The privacy concerns presented by online age verifications are glaringly dissimilar from the privacy concerns within these purchases from a physical brick-and-mortar store. Within an in-person setting, a customer must submit their identification to a real person that they can see. And with this in-person verification, a customer may clearly identify who is reviewing their information. And if a customer's information were to be compromised, a customer would be able to track down more easily who had access to their identification. But in contrast, there's no face-to-face interaction online, and therefore a customer has no idea who is accessing their personal information and for what purpose. There's nothing to say that a malicious individual or organization couldn't create an explicit website for the sheer purpose of collecting and storing the personal information of adults. And we can tell that online security risks are deadlier than in-person ones. For example, in 2018, 87,000 users downloaded porn-disguised malware, and since 2016, more than 72 million accounts from adult websites have been stolen or exposed. In-person security risks don't happen at such a magnitude or speed. And also, the internet is full of foreign, untraceable websites, and it's really not like movie theaters or stores down the street. It's nearly impossible for the government to track down and address all situations like this. So HB 1181 will deter adults, dissimilar from a brick and mortar store.
Thank you. In the years since Ginsburg v. New York, have increased technological capacities increased or decreased the privacy concerns associated with age verification processes?
Yes, Your Honor. Increased technology capacities since following Ginsburg versus New York has increased the privacy concerns associated with age verification. In 1968, an individual's concern with privacy was regarding the person that they were physically showing their ID to. However, the anonymity of the internet conceals any way in which an individual can track down where their information is being stored. As the internet has progressed, malicious entities that use ransomware and extortion sites have been more suited to target users' personal information. Knowing this, Ginsburg cannot be reasonably applied to this case, as the burden placed on adults on the internet plainly outweighs the security concerns placed on adults at physical vendors in 1968. But at the same time, as the internet has progressed, softwares to protect privacy and the welfare of children have evolved. The filtering systems brought up in ACLU versus Ashcroft is a good example of this and can serve as a less restrictive alternative.
Thank you. Online access to harmful materials presents unique obstacles to parents trying to protect their kids. If this law is found to be unconstitutional, what else can Texas do to protect minors accessing online material?
Your Honor, you're right. This is a valid concern, but there are multiple ways Texas can narrowly tailor their laws, or just simply ways that parents and guardians can protect their minors, while also upholding the First Amendment rights of adults. First, we mentioned a few times software filtering systems is one alternative, and these filters can block content by identifying certain URLs, keywords, and images. And rather than directly restricting content, Texas could hypothetically instead focus on empowering these parents. For example, the state could raise awareness about these device-based filtering systems, or require companies to pre-install them on devices, giving parents the tool to make informed decisions about their children. But at the end of the day, it's not the government's role to act in local practice for every action taken by children and every internet search by children. The Supreme Court's decision in BLV Mahanoy emphasized that government intervention in off-campus and out-of-school speech is rare and often unjustified. HB 1181 represents government overreach and undermines parents' ability to guide their own child's online experiences. Therefore, we ask the court to require strict scrutiny and reverse the Fifth Circuit decision.
Thank you. This concludes our submission.
Thank you.